916. And Detective Sergeant Grote, your name for the record, please.
Detective Sergeant Ken Grote.
All right, please raise your right hand. You solemnly swear from the testimony about to give this matter to be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
All right, thank you. You may proceed on the warrant.
After lengthy narcotic investigation of 447 Poplar in the city of Wyandotte on August 1st, 2023, approximately 12:15 p.m., Wyandotte police officers executed a search warrant at 440 Wyandotte. The search warrant was reviewed by APA Omar Shajare and signed by 27th District Court Judge Disanto. Officers forced entry into 447 Poplar after they announced their presence into the home. Once inside the home, they encountered Mr. Artest, who was seated in a chair in the living room. They also encountered another female who were both detained. During the search of the residence of 447 Poplar, officers discovered residency to Mr. Artest to include a notice to appear from 27th District Court and a delivery invoice from Bison's Health Center. During the search of the house, a blue plate with a white crystal substance all over it, a rolled up dollar bill with crystal substance all over it, a master pay card with a crystal white substance around it, and a small Ziploc sandwich bag containing a white crystal rock that was later field tested positive to be methamphetamine with a total weight of 3.5 grams were all located within, next to the chair Mr. Artest was seated in, within arm's length of him. And during a conversation with Mr. Artest later, he told me he's a drug user and the drugs were his.
All right, thank you. Upon examination of the plaintiff witness, I find the offensive charge are committed. There's probable cause to believe the defendant committed the offense. And counsel, your appearance, please.
Attorney Corey Westmoreland, appearing on behalf of Mr. Artest.
All right, thank you. Mr. Artest, your name, please.
Artest.
I'm sorry, your first name did not come through. Can you repeat that, please?
No, Artest.
Okay. And counsel, as to the arraignment.
As to the arraignment, Your Honor, I did have an opportunity to speak with my client. He did not have any further questions for me, so at this time we are prepared to waive a formal reading. My client stands mute.
The court will waive the formal reading. Sir, you have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. And in fact, you've had the opportunity to speak to an attorney today, correct?
Yes.
I'm sorry?
Yes.
All right. And you have the right to be presumed innocent until proven guilty, not a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, sir?
Yes.
All right, the court's going to enter a plea of not guilty. You may have scheduled this matter for a probable cause conference on August 10th at 9:30 a.m. And counsel, as to bond.
Yes, Your Honor. I would like you to know that my client currently is residing in Wyandotte. He currently is unemployed due to health issues. He was just diagnosed with diabetes and just had a heart attack recently. So any sort of monetary dollar would be difficult for him to come up with because he's on such a limited, if any, sort of income at this time. He does not have any pending matters. He's not currently on probation or parole. And after speaking with him, he did assure me that he would be appearing on all future court dates, and he does not have any history of absconding.
All right, Detective Sergeant Grote, as to bond.
Your Honor, Mr. Artest does have a criminal history. He's currently being evicted out of 447 Poplar. I believe he has to be out by Thursday. We don't know where he's headed. He didn't change his address on his driver's license to 447. He still had an address, I believe, in the city of Detroit. So we're going to ask 10% with the GPS tether to assure his appearance because we're not sure where he's heading.
All right, Mr. Artest.
Yes.
When's the last time you were employed?
What's that?
When is the last time that you were employed?
It's been about 5 years.
You haven't worked in 5 years? I'm sorry, that didn't come through.
No, I haven't.
When were you diagnosed with diabetes?
2 weeks ago.
When?
Weeks ago.
2 weeks ago?
3 weeks ago.
3 weeks ago. When did you have your heart attack?
A week ago.
So why, okay, those are two very recent occurrences. Why haven't you worked in the last 5 years, sir?
I've had other health issues.
And what are those, sir?
Fractured hip, 6 screws in my back.
And so do you receive any disability benefits?
I'm going through that right now. I got a lawyer.
And you're not on probation or parole anywhere, sir?
No.
Who else lives at the home with you?
My fiance.
Does your fiance have a name?
Tracy.
Would there be a last name for Tracy?
Which one?
What's that?
Tracy Bertram.
And sir, are you having to relocate by Thursday?
Yeah, I have a place in E-Course
And what's that address?
Street.
Okay, well, we have a different address for you in E-Course on your Secretary of State record. And then we have the current address on the court file here. I'm not really sure where you're going to be. And given your criminal history with similar type of charges as well, and the fact that we are unsure as to where you're going to be relocating, there is not any confirmation of that. The court finds that the recommendation by the detective sergeant is appropriate. The court's going to indicate a $10,000, 10% bond. The court will also note that for the safety of the public, the court is going to ensure the safety of the public with this bond as well. Not to possess or consume any alcohol or drugs unless prescribed. In the event you post bond, GPS Tether through Wayne County Jail. And since you're not currently working, house arrest will not be an issue. Anything else?
No, Your Honor.
Thank you. Have a good day. We'll see you next Thursday.
Thank you, Judge. Good afternoon, Judge. Attorney Corey Westmore, I'm appearing on behalf of Mr. Cleaver. Mr. Cleaver, please state your name for the record.
Your name for the record, sir.
Stephen Daniel Cleaver.
All right, thank you. And Mr. Cleaver is currently on probation. Well, he's actually not on probation. The court sentenced Mr. Cleaver to 93 days credit, or 93 days jail credit for 55, 38 days jail suspended pending review. And he has a GPS tether. Actually, let me see here. I'm sorry. On probation for 24 months. In addition to that, the court indicated 93 days jail credit for 55 days, 38 days jail suspended, the jail review. The court will also indicate not to possess or consume any alcohol or drugs unless prescribed, random testing, intensive outpatient substance use counseling, not to return to the home on 19th Street, no weapons or firearms, 26-week domestic violence counseling, mandatory incarceration for any violation of probation, revoke under advisement status for any violation, 45 days alcohol tether, and then contacting probation and whatnot. There's an allegation that Mr. Cleaver violated his tether, well, violated probation by entering into an exclusion zone on July 31st, from 12:51 to 12:54. And there was a jail review scheduled for tomorrow, so I might as well just handle that today too. So I'll just come back tomorrow as well. And so counsel, as to the allegation your client.
Yes, Your Honor, I did have an opportunity to speak to Mr. Weaver regarding the allegation. At this time, we are prepared to enter a guilty plea. I did explain to him his right to have a hearing on this, and we are prepared to waive that right at this time.
All right. Sir, please raise your right hand. Do you solemnly swear from the testimony about to give this stand be the truth, the whole truth, and nothing but the truth?
I do.
All right. And sir, you heard the plea that your attorney indicated, correct?
I did.
All right. As to the allegation that you violated a term of your probation by entering into an exclusion zone on July 31st of 2023, how do you plead?
Guilty.
You've gone over your advice of rights for probation violation purposes, correct?
I do.
And as to those rights, you understand all of those rights.
I do, Your Honor.
And you understand by entering into a plea that you'll be waiving some of those rights, specifically your right to a contested hearing.
I do.
You understand the possible penalty as a result of your plea.
I do.
Understand this court could specifically on its probation order revoke your under advisement status and also send you to jail. Do you understand that?
I do.
And knowing all that, you want to still continue with your plea.
I do, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
All right, counsel, if you can please ready your client.
Sure. Mr. Cleaver, are you currently on probation for the Wyandotte District Court?
I am.
As a term and condition of your probation, to not drive past the house located at 2466 19th Street in Wyandotte.
I know that now. I didn't know that I wasn't allowed. All I did was drive past. You can see it was only 3 minutes.
We'll get to that, Mr. Cleaver.
Okay. I do.
You understand that that is a direct violation of your probation?
I do now.
Did you in fact drive past that home on July 31st of this year?
I did.
And you understand that's a violation of your probation?
I do now.
Satisfied, Judge.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation. And counsel, as to the recommendation that under advisement status be revoked, your client continue and complete all terms of probation, a $50 probation violation fee, serve 10 days jail with an additional 30 days on the tether, as well as the alcohol tether as well.
Yes, Your Honor, I would simply just ask for consideration for leniency. He has been extremely good with probation to this point. He does not have any violations, no alcohol violations. I am holding an order for his tether. It's depending on how you want to look at it. It does say do not go to 2466 19th Street. I understand that also means that you're not supposed to drive by or go anywhere within the surrounding area of that. He was just driving by to make sure that his yard was being properly taken care of. He didn't contact the individual in the home. He didn't walk on the property. He simply just drove by. I explained it to him. He understands that he's not to do that again. This is not going to happen again. So with that, Your Honor, I would simply just be asking for leniency on behalf of Mr. Cleaver. He is extremely apologetic. He took responsibility for it, and it's not.
I'd like to take a look at the yeah, there, please.
Make any mention about how far he's supposed to be at all times. Just says don't go to the home located at that address.
This is a supplemental order Sir, you're telling this court that you were not provided any sort of information regarding your exclusion zone, that being the home address on 19th Street with a 1,500-foot radius.
No, Your Honor. I had no idea. It'll never happen again.
And so at some point, were you notified that you were in an exclusion zone? I'm
My
sorry?
leg vibrated
Okay,
and I got immediately out of there. It's gone. I live in Woodhaven now. And I go to a big boy restaurant across the street from the police department. And it's vibrated there also. I've gone to CVS at Northland 4th Street. And it talks.
hold on. You live in Woodhaven, why are you going to CVS and Wyandotte?
That's where my Dr. Ibrahim is, right here on 4th Street between Northline and Oak. And that's where I've been having my scripts sent for years.
Okay. Sir, this indicates that you entered via Walnut Street and you exited via Vinewood, correct?
Correct.
And this shows that you were there for about 3 minutes in that exclusion zone, correct?
Correct.
Were you walking or were you in a motor vehicle?
My brother-in-law was driving and we just drove past the house to look at the yard. That's all it was.
No. Just driving past, you would have maybe 10 seconds. Because you have Walnut, then Poplar, then Vinewood. Okay, so it shows 3 minutes. 3 minutes. Would you like me to sit here and run a timer as to how long 3 minutes is, sir?
No, Your Honor.
So don't tell me that you just drove past to check out the yard and that's all you did, because you were within that zone for 3 minutes, which may not seem like a long time, but I know driving 2 blocks does not take 3 minutes.
That's all we did was drive by, Your Honor. That's the truth.
Well, sir, your credibility with this court is not great. You've violated multiple times on bond by contacting the complaining witness and trying to have her contacted and sending letters and then claiming you didn't know you couldn't do that.
That was
So
when I was in jail, Your Honor.
I understand that.
Okay.
And now you're out of jail. And you found it necessary Monday, to drive by to check on the status of the yard.
Just did it because I was in the area picking up prescriptions.
It's not gonna be replicated again in the future, Your Honor.
I'll never do it again.
If you wanted to know how the yard was looking, you could have had a neighbor tell you how it's looking. And if it wasn't looking good, what was your plan?
I was just curious. You know, the divorce papers and everything are sent in, and I was just, just checking on the house.
Who was awarded the house in the divorce?
I don't know.
It's not finalized yet.
Oh, I thought you said the divorce papers were sent in. I thought you meant
Well,
the judgment.
paperwork's all sent in with papers to get a court date and all that shit. House. I just want all my belongings out of there when I'm allowed to go get them.
I'm sorry, what did you say about your belongings?
She can have the house. All I want is 50% of the house. and my belongings are there, my tools and whatnot. I was already allowed to go in at one time with police escort, get some clothing and stuff to get by. I haven't been back since. I haven't tried to contact her. There's no third party tried to contact, nothing. Trying to do what you told me to do, stay away.
Except for Monday.
I didn't realize it, you know, it was that big of a mistake just to drive by, and I apologize.
But so you didn't just drive by. You sat there and you were watching the house.
Honestly, I didn't stop.
So it doesn't take you 3 minutes to drive 2 neighborhood blocks. Walnut, Poplar, Vinewood. That's where you said, it says you entered at Walnut, you exited on Vinewood. Walnut, Poplar, Vinewood. Right?
Actually, it's Walnut and then Vinewood. There's no poplar there.
Okay, so Walnut, Vinewood.
Yeah.
For sure not 3 minutes. For sure not 3 minutes. But that's how long you're in your exclusion zone.
The shortest 3 minutes I've ever had, but that's what the tether says, it's what the tether says. My brother-in-law was driving, I'm not allowed to drive.
All right, and council, as we are handling the jail review as well, I'll render sentencing on both of these at the same time. So what would you like the court to know regarding the jail review?
Judge, I didn't have any information on the jail review.
Oh, that's right. Okay, do you want a moment to review that?
Sure.
Okay.
Okay. I had to start counseling. I started counseling in teen wellness. Sorry. I can have an email. I talked to my counselor yesterday via phone. She said she'd email it here if I had an email address.
Okay, so council after the jail review.
Yes, Your Honor. I believe his probation officer has not received notice of proof of his counseling that he started. He's indicated to me that he has started it. He just needs to get an email address so he can provide and verify proof that he has started it. Again, Judge, I'm simply just looking for leniency on behalf of Mr. Cleaver. He's trying to get his life in order. As you heard, he's going through a divorce now. He's struggling just so any leniency on behalf of the court would be greatly appreciated.
Sir, when did you begin your counseling?
Counseling, as soon as I get out of jail.
So that's been over 2 months.
Yes, ma'am.
So,
Started with the therapist. I have a shrink now, and I'm starting anger management classes every Wednesday at 1 p.m. My counselor or therapist asked me yesterday when I was on the phone with her if I needed her to email to the court, and I told her I didn't know it, but I would find out, and I could have her email the information to you.
well, sir, how else would we know that you're participating in your counseling if you don't have your treatment provider submit that information?
I can get that information, ma'am.
And I'm sure your probation officer has informed you to submit proof, right?
Not that I'm aware of. I only seen my probation officer once since I've been out of jail. It's only been a month, and, I'll see her, I saw her on the 13th, and I'll see her again on this coming 13th. I could get the proof sent over email before that.
All right, here's the court's going to do. As to the jail review, the court's going to indicate we are going to adjourn that jail review to September 19th at 10:30 a.m. As to the probation violation for your entry into the exclusion zone, the court's going to indicate that you're to continue and complete all terms of probation. The court's going to revoke your under advisement status per the probation order. The court's going to indicate a $50 probation violation fee. The court's going to indicate 10 days jail. The court's going to also indicate an additional 30 days on the GPS tether after you serve your jail term, and alcohol tether as well.
Judge, would you consider suspending that jail sentence at this time? He's not trying to contact the individual that was there. He meant no harm by it. It's not going to happen.
I appreciate that, counsel, but I'm adjourning the jail review and not sending him to jail for the 10 days that was recommended on that. The court's going to not do a review on the exclusion zone. The court has concerns, number one, with Mr. Cleaver's credibility. Number two, there was absolutely zero reason for him to have driven by the house, checking on the house or otherwise. It's occupied, it's not vacant, and the fact that he was in that exclusion zone for 3 minutes, even if it was a minute, that's still too long. So the court's going to indicate 10 days jail to be served on the violation. 10, and you're starting that today. You're going out through this door today, sir.
After these 10 days, and you still want me to go get verification of my counseling and all that. I've got 3 or 4
Yes.
dates already set up for counseling that I'm not gonna be able to make.
You can contact your brother-in-law or whomever it is that you communicate with to contact your treatment provider to let them know that you won't be able to make anything within the next 10 days.
Okay.
Thank you. Oh, you know what?
What do you want me to
Have a seat right here.
That's fine.